Okay, part 2, day 9. They're doing jury instructions still. Here we go.
Yeah.
The defense, are we back on?
Go ahead.
The defense's position is that Rosenbaum was yelling gun, gun, gun. Why do you think he was yelling gun, gun, gun? Because Mr. Rittenhouse had a gun. No, I mean...
Oh, yeah, I'm not trying to interrupt you.
Yeah, the court is exactly right. We would have to prove this. We have testimony, video, and photographic evidence of this occurring. It is our burden to prove it. I agree. But the jury should be given the instruction that they should consider it. Because if he raised this gun, it's clear provocation. So it's up to us to present the proof, which obviously will be a central piece of our closing argument with the, I think, 3 different videos, this defense exhibit, which at least indicates that it's there, and the testimony of Detective Antaramian, who indicated he saw this, I believe, after cross-examination or on cross-examination. And the jury can decide it. We don't have to prove it beyond reasonable doubt to the court or to the defense right now. We have to prove it beyond reasonable doubt to the jury on Monday. There is plenty of evidence in the record to indicate that, to give this instruction. I understand it's problematic for the defense. I understand it's problematic for their entire theory of the case that they presented in their opening. But that doesn't mean that
he's kind of giving a slight dig to these guys that it's problematic to you because you don't know how to fight against it and we're beating your ass. That was a kind of lawyer jab.
We shouldn't get it because we have presented evidence of this provocation that the unlawful conduct provoked Mr. Rosenbaum to attack him. If the jury buys our argument beyond reasonable doubt, fine. If they don't, that's their prerogative. They're the fact finders, not the people in this room. We have presented facts for them to consider. They should be given the opportunity to consider those facts in this light.
Judge, I don't think that photograph, maybe I'm wrong, shows anything.
Well, that's for the jury, though.
I understand, but they're asking out of that photograph to give a provocation instruction.
No. We're saying
There's no other evidence.
We're saying that
No, just a minute.
there's no other evidence.
We've talked about the chase thing, right? But every other thing that's come up about what Detective Antaramian said, what anybody else has said, comes from that photograph. That's it.
No, it comes from the drone video. And the defense knows this, which is why they've fought so hard to keep this out. This is not some new revelation. It's in the police reports. There are allegations that he pointed this gun. This is only to demonstrate that a defense exhibit indicates it. We're not using this to prove it. We're using it to show that even the defense exhibit indicates that this is there. We have testimony. We have video evidence. We have, I believe, photographic evidence that helps. But to say that we're basing it on a blurry photograph is completely dishonest. They've seen this video and they know what's on it, and they know it is problematic for their defense.
Yeah, I can't rely on what you think they think.
I understand. I'll change my argument. But the simple argument is there's plenty of evidence that the state has provided that he raised his gun. It was a known part of the discovery in this case. We should be able to argue that, and we would argue provocation, so the jury should consider it. And they clearly, as they pointed out in their evidence and their opening and their argument today, they can rebut that and indicate we have not proven it. And that's up to the jury.
So why do you think this instruction is important to the DA's case? Their whole case is that Kyle is the aggressor. He went out there with a gun. He was looking for trouble. He provoked this. He was putting out fires that the friendly unrest people were lighting, and therefore it was provocative, and he was encouraging them to attack him. So by having this provocation instruction, it helps their case. They can refer to it, and it's just one other thing to confirm what the lies they're trying to tell.
That is not up to us. So I believe we should give the instruction is appropriate. It's add the following when supported by the evidence, and it is supported by the evidence.
There's been no secret about my lack of technical awareness in the trial here, and I thought of it. I decided not to intervene yesterday. I did ask Mr. Armstrong some questions to try to better understand what was going on, but I didn't go further into it in spite of a temptation to do so. When I get messages from some of my friends, my few remaining friends, they come as texts, and then they start belittling me or whatever in one way or another, and it can be quite lengthy, the exchange that's going on between them and us, but they're entertaining, and so I don't know how to save text messages. I haven't figured that out, and I have a lot of things that I'm doing, so that's a low priority for me to figure out how to save a text message, and I don't want to leave them on my phone forever. I want it off so that it's clean, so when I look at it, I'm looking just at the fresh stuff. So then I do a screenshot of it, and I email it to myself to save it. But I found, to my distress, some of them are pretty long, and they show up in my email like this, like a little ribbon down the center of the page. Some of them are even smaller than this. Well, then I go to open them up, and it's just a blur. You were talking the other day, one of you two, about it's just like a cell phone where you can expand a picture and make it bigger. Well, it's not making it any bigger. I mean, it's making it bigger, but it's nothing.
I mean, that's a great point that he just made, and I can't explain it. Maybe the video guy could explain it, but anybody in the future that does this, that's a great example. I'm sure it has something to do with a long picture, or it sounds like he copied the big long text. Because when you do a screenshot, it will only screenshot what's on there. So I think he copied all of his text, and that's why it came out small. But I could be wrong. I'm no freaking expert, although I was qualified as expert, and when I used to do computer crimes, I was kind of up on the game and certified on the software and all the other good shit. But anyway, here we go.
But a blur. That was my concern that I wanted to ask Mr. Armstrong about, and I guess I should have, for him to explain it better for me as to how that can be reliable. Because it isn't reliable for me in getting my messages on my phone. Now, maybe if I reset it to a site, I could explode it again or decrease its size again, and I don't know. But here you've got a picture, which I have to tell you, I think it's very blurry.
I agree. And the picture is one of 5 or 6 pieces of evidence. So I know the defense wants to focus on this picture, but the picture is only one. We have 3 videos. One unedited, completely untouched drone video, which I think is where you see it clearest. And then we have one that is zoomed in, and we have one that is slowed down. I believe the clearest shot is actually the original drone video. So we can present that evidence, and they can rebut it. I think you're taking the picture wrong on your phone. I'm not texting for it.
Pardon me?
I think you're taking the picture wrong on your phone.
Is that it?
I think so.
I'm not surprised.
But these things are in evidence. You watched it on the screen yesterday, whether you formed your opinion or not, and that was
my
probably
opinion is not what counts, except to the extent that if it's just totally unclear, then I certainly can't give a provocation instruction based upon a picture that I can't make anything out of. I agree with you. The ultimate determination of what it shows is for the jury.
It is not
You
based
have
on
to
the
be over the threshold.
It's absolutely not based on the picture. It is based on the drone video and the testimony. And this was testimony elicited, if not by the defense, then in response to their questioning. Detective Armstrong testified he reviewed it and saw it. And that was a common question to many people in this case. The photo is like the 5th or 6th most important piece of evidence. The most important piece of evidence on this point is the drone video itself. And that is unedited. There are some edited copies as well that are helpful. But to focus on this photograph, that was almost an afterthought simply because we didn't get it till the day before, and we figured it may be helpful at some point. The photograph is, we may not even show that to the jury. It is based on the drone video and the testimony of Detective Antaranian. It is in the record. We have evidence of provocation.
Look how much arguing the jury misses, and confusion, and different sides of the aisle, and this word and that word, and what was in and what was out, and what he said and how he phrased it. And this is why Bill Clinton, when he had sex with an intern in the Oval Office, had him please define is. Because he wanted each word. His lawyer wanted him to define is. That's what lawyers do.
I can't fathom why, if there's evidence in there of provocation, which we have clearly done, why we cannot argue it and why we cannot get that instruction. The defense is free to completely call it whatever they want and to attack it. But that is why we have trials.
I haven't seen it clearly, okay?
I have.
Oh,
Your Honor, they're arguing for something saying we've been on notice from the beginning. And if they wanted to put on the evidence to prove up provocation, all they had to do was call Mr. Zeminski or Mrs. Zeminski to rebut the story that we have. They didn't put him on because Detective Antaranian, Detective Howard both know he's a liar. And they're building their whole prosecution on that without putting him on.
well, they don't have to call a particular witness.
But they don't have the provocation. And, we had all these little things going on yesterday, and I went back to my office. And the whole essence of the problem came down to these 2 facts in the testimony. Examiner Armstrong took 20 hours to manipulate that photograph to get that blurry mess up on the screen. We had our expert do it right in front of the jury in seconds, and it showed what it was. And that's where the hocus pocus and adding the pixels and all the other garbage comes in, and that's what they're building their prosecution on.
Again, we're focusing on a picture that is we're focusing on a picture that I've said repeatedly now is the least.
Well, show me the best one.
What?
Show me the best one.
Your Honor, yesterday, before Mr. Armstrong was allowed to testify in rebuttal, we went over this about whether or not the methods he was using were appropriate, and we showed you. You walked up to the 4K TV, and we showed you exactly what it is we're talking
And
about.
I'm not even going to tell you what I thought when I saw it.
And Judge, this is not a court trial. You have to find your fact. We have facts.
I know it, and that's why I let it go to the jury.
That's what we're asking.
That's what we're asking, is that the jury be allowed to consider the state's evidence, is essentially what we're asking.
I don't think, Your Honor, you would have allowed Mr. Armstrong to testify yesterday. I don't think you would have allowed him to testify in rebuttal, unless you had made some determination that there was some basis for this.
What I made a determination was that I thought the jury should make the decision.
And that's all we're asking.
So that's your best picture, the one I saw over there?
No.
Where's the best picture, please?
We'll show up to the finder of fact.
You're asking me to give an instruction. I want to see the best picture.
I love it when he has a little snack of weasel in the middle of trial.
Get Mr. Stewart over here, I think.
You need it on the big TVs.
You need another big TV?
No, I think the best picture is on the original drone or the normal speed one.
70 degrees on you say so.
I'm proud to be an American. I love his phone ring.
Judge, I think using the defense, we've got the exhibits on our one of our laptops that I think Mr. Stewart has. I've texted him to come on over, but I think Ms. Wisco is graciously going to be able to play them for you. I would recommend watching them on the 4K TV. I think that's the best way to see them. So we can set that up. There is the full drone footage. There is the slow down drone footage. And then, of course, we have the photographs that Mr. Armstrong had yesterday.
So we're going to redo evidence because we didn't do it during the trial.
Yeah.
It's not 4K quality.
What's that?
Is it, this TV,
It's your TV.
adds pixels to something unless it's 4K quality. It does.
Where's the evidence on that?
It's common sense and judgment, Jim.
That is a very good point about, and I think I read one of the comments about they haven't addressed that every screen can give different colors. When I go buy computers, I look at the different colors, and some manufacturers, whether it's HP, Dell, whatever, some have better looking images. When you buy a TV, some people like certain TVs because they have a better picture. So, and I don't know in pictures if they're, if they've got AI technology fixing shit while it's showing or HD, but they didn't even get into quality of video. All they really got into is frame per seconds and adding a few pixels. So there was a whole bunch of other stuff about what can make a picture clearer, brighter, more vivid. I mean, so is the jury watching it on the same screen that the judge is watching it? And I mean, there's just so many X factors in this piece of evidence. I'm surprised the judge is allowing it to go on this long, but he's trying to be fair, and he doesn't want to come off like he's, hindering the prosecution's case.
There's no evidence on that.
Are you saying I'm lying?
I have no idea.
I'm saying there's no evidence on that.
I'm asking.
Wait,
you saying
maybe
there's
another,
Well, it's common
First of all,
sense.
You brought in the TV to show the exhibit.
Yeah,
brought in
4K
TV.
drone.
You brought in the TV to show the exhibit. So that's what we're doing.
Well, he messed up his little ducky do. Don't be smiling, Kyle. Don't get relaxed. You'll be getting in that boy's ass, trying to save your life. You want to smile,
Okay.
think of me chewing your ass.
Yeah, this is the end. 73. So, Judge, we're going to be focusing your attention right here at the base of this sign. Okay, that's where the defendant is going to come into. Go ahead. Okay, you can stop this. We're past it now. Yeah, this is the same quality as our version, is it? Yeah.
Our version is much clearer.
Yeah. We'll have to get a...
I have the enhanced one, but that is exactly what we got from you. I have one straight from Dropbox.
Yeah, Mr. Stutz.
So what you're showing me now is, this doesn't show anything. This is flash was provided to the defense?
Yes.
I can't hear shit.
Mr. Stutz, out of the way. Here.
So if your version's clear, that means that you didn't give us.
Kyle, don't make me knock that frickin' smile off your face. They're gonna have your face plastered all over the news with you smiling if they get it. Freaking left-wing media. what's he doing? Zooming into pictures that are taken with high quality cameras? I mean, what camera took that picture? What lens? What's the magnification? I mean, this isn't a good comparison to me. I lost all sound now. If we're losing sound, I guess I'm just going to bop through here. You can see some of the pictures, I guess.
Is this the zoomed in or the regular?
This is the regular version.
So we're looking right here. This is the defendant. He puts it down, he raises it up right there. And he has it pointed until Rosenbaum approaches, then he runs around.
Try it again, please.
Play it
Try
again, please.
Can you-
Right here's the gun. Right there's the gun right here. Oh, wait, no. It looks very similar to that when he points it here, Mr. Rosenbaum.
One more time.
Here, Stu, let me pause it 1 second in, please.
Start playing.
Pause.
Pause.
Right here. If you watch it, when he goes right up here, he puts the fire extinguisher down gently. It topples over, and he immediately raises up like this. And the gun is right, we argue, right here. And he stays in this position like this until you see Mr.
Okay, that's a ready position or a port arms in the military. They would call that port arms. That is a normal position to hold a gun with two hands. It would be awkward and not reasonable for him to lower his left shoulder when a gun is hanging low. As soon as he held the gun to protect it with both hands, he had to have it at some sort of 45-degree angle going in the air. It wasn't necessarily pointed at him. That's the normal course of how you hold a weapon. Come on, defense.
Rosenbaum come around. So Mr. Rosenbaum, if he is yelling gun, 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 we would argue it's to warn all these people that he is pointing a gun at them, and that he is chasing him out of the area to avoid danger. But if you see right here, as they believes, with all the motions taken,
You can't say that Rosenbaum was warning the people in the area. He could have been telling his buddies on who to attack. I'm chasing a gun, and I'm going to get that gun. You can't make up what Rosenbaum yelled gun for. See, he's testifying, but luckily it's only in front of the judge. The jury won't hear it. But he's still lying in order to get the judge to rule with him.
that's the gun. And here's it's right here.
Is that where Mr. Rosenbaum feels you're not going to do shit enough for?
We can talk about this at closings if you want.
I was just curious.
What's that?
I was just curious.
All right.
I'm no expert, but when I want to go frame by frame, I upload something to YouTube, and then I'm allowed to go frame by frame on YouTube, and I can slow it down and speed it up. Evidently, no one over there has a clue on how to set something up for frame by frame with their so-called hot shit computer program.
So why don't you play from the beginning one more time? You see him drop it right there as Mr. Rosenbaum approaches. Or lower it, I should say. Would you like the zoom in or slow it down?
Rats,
I have to see the enhanced one now?
Okay, normal speed or slow speed? Do that the zoom in normal speed.
Zoomed in normal speed.
Do you need a number?
Yeah, I think
Or for the request?
15 is on his chest. The fire extinguisher you can't see right now, it's blocked by this man in the wheelchair. But you'll see him walk up again. He will gently place the fire extinguisher on the ground.
You hear him say that? I knew that was coming. I couldn't pause it in time. I was going to say he's going to make a big deal and highlight it down. He said gently place the... You can absolutely 100% respect in the closing. They will say, do you remember when Mr. Rittenhouse testified he dropped the fire extinguisher because he was so scared and he had to grab his gun? And, well, he actually gently set it down on the ground. Watch, it'll come.
See right now, it's blocked by this man in the wheelchair. But you'll see him walk up again. He will gently place the fire extinguisher on the ground, although it will fall over, and then he will immediately raise his gun up and point it.
If he gently laid it on the ground, it didn't fall over. Sorry about that. I'm like the judge. I got timers and shit going on. Here we go.
At the individuals who are over here, who I think are right now blocked by this street light. But there is an instance. Okay, go, Brian. See him lift it right there. He's holding it right there until Mr. Rosenbaum approaches. You see the very distinct motion of him raising his arms, and you see the black gun being raised. One more time, please.
You'd agree if that's true. He's doing it. open to the camera.
Well,
So
you know what?
No,
you know,
no, I did not say that.
it's okay.
Yeah, please.
Slow down version, please.
I'm not even sure we're going to see anything. They could,
Play it, please. So he's coming in frame, he drops the fire extinguisher, and he raises it right up. He has it up right there, you see him bring it down, and you see him probably is vandalizing or committing arson, but he fires it,
I didn't hear what the judge
what,
said.
I'm sorry?
I said, where's Zeminski's gun? I meant, what I meant to say was, does it depict Mr. Zeminski, or
Shooting?
Mr. Zeminski's gun?
At this point, no, it does show him shooting in the air.
Oh, that's over later, over there.
Yeah.
But I'm talking about at this point.
I don't believe it shows Mr. Zeminski's gun.
Does it show Mr. Zeminski?
Can you play it again, Brian? He's kind of
Or
hidden.
Mr. Zeminski?
They're kind of hidden by this light
I
post.
know, that's what everybody is saying. I'm so sorry.
Okay, that's all right.
Is it okay? Do you need me to record?
okay, we're going to give this to the jury because they can figure it out better than we can, watching it 14 times, reversing, having a computer expert, all that. We'll just give it to the jury and let them figure it out. Perfect.
Yeah, because it's argument. What I inquired is, well, wait. You get
FBI video by the Duramax, but because they're darker clothed and the Duramax is a dark vehicle, and of course other issues with the video, it's not, and there's poles and things, so.
And the weasel comes in.
Which we can show you guys.
I've seen it.
It might be helpful after seeing this now to see that because it kind of gives you a.
I wonder if this guy's doing most of the talking because the weasel knows that he's already pissed the judge off.
If you play it, I think I can play it, please, Brian.
Go ahead, Larry.
I believe they're blocked by the light post. But the story that he had his gun out of his pocket. So unless he makes his story, him pull it out of his pocket. And
You can see the gun clearly in his hand.
Well, I guess it sounds like a great argument.
You're going to see, I'm cheating here, right here. You're going to see what you believe that you see. Okay, so the question is, does that video
He's even got the microphone. He can't even hold it to his freaking face and talk.
provide enough information to give an instruction on provocation?
And how, just if you take everything they said, and that's true, how does pointing a gun at Zeminski provoke Rosenbaum, who they say they don't know each other?
there's no evidence of that on a real basis.
Well, the evidence is okay. Rosenbaum had twice before threatened to kill the accused. So is it, what is the legal effect of a person who, if he made such a threat, what legal justification does he have to chase after the accused? In such a way as to not put the defendant into a position of being a provocateur.
We are absolutely
That's
not.
how I'll phrase it.
We are not accepting the evidence that that threat was made because there are different accounts of where and when it was made, and it's like the only 5 seconds not caught on video all night. So, but like you said,
You can expect to hear that in the closing. This phantom statement that Mr. Rosenbaum, our great victim that we're defending, somehow it's the only 5 seconds out of all the video footage you've watched that wasn't captured. This mysterious statement to where he threatened him twice is the only thing that was never captured on video. Man, they are gonna, when you see how they argue, it is such smoke and mirror and lies. I mean, it's almost criminal.
you said, Judge, it'll be a great argument, and I do not believe that Mr. Rosenbaum does not give up the ability to be provoked because he may have said things an hour earlier. If this individual, now remember, there is evidence in the record that he was accused of pointing guns at other individuals for property crimes. The defendant admitted he responded sarcastically to one of them. On the video, he sort of sheepishly and quickly walks away.
See, he really misrepresented when he said, I kind of sarcastically said I did. What he should have said is, when he said that, I was kind of taken back because I know I didn't do it, and I just kind of said, I did? As a question, and then I didn't want to get into it, and I walked away. That would have played a lot better, but he used the term sarcastically, and now they're going to be able to manipulate that he was being a smartass, and he admitted that he pointed, and he knew he pointed, and that's why he sarcastically said it.
After admitting he pointed a gun at someone for property crimes. The state's belief is that he pointed a gun at Mr. Zeminski for another property crime, and this dangerous behavior, pointing this loaded, powerful weapon at someone for, at the most, perhaps.
How many of you people seen cops point their guns at somebody? Are we ever in front of a jury and a judge and the DA is saying, man, they pointed their gun at a citizen and it's very dangerous, and they pointed their dangerous gun and they probably had ball ammo or a hollow point, and it was really dangerous to the people that they pointed at, and we have to charge. How many times have you heard that shit? And how many times have you seen cops pointing 50 guns at somebody when they don't even have a weapon, and there's 10 cops and the person has his hands up and everybody still has their guns pointed at him? I mean, the cops point guns at people and they don't even have to say, I'm going to kill you. They don't even have to chase the cops. And the cops point guns at citizens every stinking day. And you've never seen this. The hypocrisy of going after this kid like the DA and the state is protecting the community is just freaking an outrageous lie.
Stoking a fire that's already been lit would be provocation. Committing this unlawful act would be provocation for anyone to intervene and try to chase him away, whether or not threats have been made. And
so let me ask you something, Mr. DA. If you slip and fall on somebody and they die, should I be able to charge you because you had a big lunch, because you didn't buy good enough shoes, because your balance was off, because you didn't go to the gym, because you weren't paying attention, because you were reckless? You should know that if you fall on somebody, the likelihood of smashing and killing them is there, and you disregarded that threat, and then you slipped and fell on my client and he's dead. So you should be charged with murder. Are you freaking kidding me? I mean, it's just absurd.
I know Your Honor takes these threats seriously, but we've also seen thousands of threats to kill that have never been acted upon. This guy, Mr. Rosebaum, was described as a babbling idiot. There's no evidence he ever caused any physical harm to anyone that night. And frankly, even if he had threatened, he had no means to carry out his threat. So
actually, arson is a violent crime because every fire that he lit, whether it's a trash can or not, had the potential to spread, explode, put caustic toxins in the air that people breathed, could have made them sick, the wind could have blown ashes to a building, lit that building on fire, people could have died inside that building. So actually, he was committing a lot of violent acts that endangered a lot more people than my client, Mr. Rittenhouse.
So, as you said, it's a great argument. There's evidence in the record, not just by video, also by testimony, and there's enough evidence to give this instruction. If the jury does not accept this argument, if we do not meet our burden, that probably is beneficial to the defense, but it should at least be argued as the evidence does support it. And it goes directly in contrast to what the defendant testified to.
Is there a jury instruction about a fucking idiot that chases a guy with a gun and grabs the barrel? Can we have that jury instruction read to the jury, Your Honor? Because Rittenbaum was freaking chasing after a guy he knew was armed. He was throwing shit at him. He was threatening to kill him. And then when he grabbed his gun and got shot, everyone here is acting like they're surprised and they can't figure out what happened.
It's the jury's case, and I think they should make the critical decisions.
Just say you're going to think about it and then deny it later, Judge. Don't even deal with it.
My decision will be to submit the case to the jury with the provocation instruction, and you can argue the strength or lack of strength of the respective evidence. So I will give that instruction, and I'll give the... You didn't dispute the retreat, did you?
I don't think it's, I did. I don't think it's, if you look at the comments, it's not necessary. It says right in the comments, the committee concluded that while reference to duty to retreat is arguably unnecessary, given the potential relevance of retreat to the reasonable use of force, it's advisable to continue to publish it. It is intended to be optional in the sense that it is to be used only when the trial judge concludes that retreat is an important issue in the case, and the jury's understanding will be aided by a statement of rather than the general...
He ran and was pursued and chased and attacked. How much more of a retreat do you want? Does he have to have a helicopter standing by so he can hook in and fly off? I mean, how much more retreat do you want?
Legal standard that applies. So I don't think that under these circumstances there's any, can't say it's unfavored, but if you look at the comments, there's no reason, in my opinion, to give it. He does retreat. There's no argument about that, but I don't think it's necessary to be given.
Judge, I believe that it is appropriate in large part because this was, that there is no duty to retreat was mentioned in opening. I believe Attorney Trofsky referenced it in a cross-examination that the defendant had no duty to retreat. So I believe that there should be, that's been put out to the jury. There should be a fuller explanation of what that means, that they can decide and they can see if there was opportunity to retreat. We see the defendant...
Why is it now, do y'all catch this? Somehow now Laurel and Hardy have this huge thing about wanting the jury to hear everything and wanting the jury to decide everything. And during a whole trial, it's been nothing about lying and disparaging witnesses and bending the truth and restating false testimony. I mean, this guy has done nothing but lie this entire time to the jury. And now suddenly, the jury has to have the information so they can make the best decision. You guys are so unethical. I just wish more people could see it instead of thinking, "Oh man, that's a DA. Those guys work for us. That's really good. They're not going to lie. They're better than the cops. I mean, they're just really super people." And I mean, oh God.
Has plenty of open space in which to retreat. He does so right after shooting Mr. Rosenbaum, and also.
Well, yeah, no, I'll say that. Everybody was scattering then, and that dramatically changes the situation.
If you look at the FBI video where he ran to, there was absolutely no one there before the shooting.
If there was no one there, where the hell did all those 1,500 people come from that were running away from there? You freaking idiot. What? I mean, Your Honor, I went there and there was no donuts. There was 50 donuts. You ate them all. Now you're trying to say there was none there?
The FBI video does not pick everybody up. The Zanin video shows it clear as day. There's 100 people over there bashing on windows.
Yeah, the Zanin, I don't remember which it was. I think it was Zanin. Video to me depicted a large number of people who were engaging in violent activity. Well, property violence, but it's still, they're using clubs and wrenches or whatever else to be.
They were using potential weapons that they would have used on him, which they did use on him, like a skateboard, like the bottom of their foot, like a gun in his hand.
Doing destruction to those cars that are right in the area which would have been the path of flight for the accused. And I'm wrong about that?
Yes.
Oh, in this video, you hear the 5 gunshots. You hear the first gunshot, which is Mr. Zeminski, and there's kind of a flinch of the crowd, and then you hear the 4 shots that Kyle fired.
Yeah, let's have a look at it. The shooting went on riotous activity.
I agree that in the southern portion of the walkthrough is, the defendant testified that his first instinct was try and head north on Sheridan, that he could not because Mr. Rosenbaum was there. But as their testimony is that he was somehow trapped or blocked in these rather loosely parked cars. And you will see, I believe in the video, that the route the defendant takes after shooting Mr. Rosenbaum.
I don't want to hear about after, because after, that's a different situation entirely.
All right, well,
watch the video. Let's watch the video. We'll put the sound on if it's there.
Yeah, there's nobody there. According to the DA, there's no one there. Yeah, he's right. I don't see anybody. It's like a vacant lot. Nobody's there.
Can you pause it, please? Or go back 2 seconds? The defendant runs here. There's no one in that area.
I go by the same
Gunshots. Which comes in a minute and 10 seconds approximately.
Yeah, I don't see anybody. I don't know where they're coming up with there were people over there, because I don't see anybody. Y'all see anybody? The DA, who wants the jury to have all the information, said nobody's there. I should just listen to the DA, because obviously he knows. Wow, I don't see. Look at that vacant lot, just empty. But then again, he's been calling these guys unrest all night, and they're jumping on cars and destroying shit and lighting shit on fire and throwing chemical bombs on people. And it's just a little unrest. What a couple of lying government flunkies. Damn, that DA was freaking on it, man. I really, when I first watched this, I thought I saw some people. But after the DA told me that it was empty and there was nobody there, I got to change my mind.
Oh, shit.
Wow. Wow.
They shooting.
Look, nobody's there. Look, the screen is empty.
Oh, my God. Oh, shit.
Nobody's there.
They shooting. my God.
It seems to me that there's quite a bit of flight from that otherwise congested area after the shots are fired. So prior to the shots being fired, there were quite a crowd there. What?
Judge, I don't believe there's a crowd where the defendant.
Dude, I bet you if there was a dozen donuts there, you'd be able to find it and see it pretty easy.
Ended up retreating too, but
Ended up is after the shooting had occurred.
I understand. So my main reason for wanting this instruction, or our main reason, is that the defense has already stated that there is no duty to retreat. So they've already put that in evidence. I imagine they will argue it again in closings. So I believe the jury should properly be able to instruct on the law regarding retreat.
Do you want to respond?
Your Honor, he's arguing the instructions. I'll keep my mouth shut. I said he's arguing the instructions. I'll keep my mouth
You saw the video, Judge. There's hundreds of people with weapons causing damage. What happens after doesn't matter because it happens after. And I'm trying to do.
So this attorney is doing what he should do. Anytime you've got a judge saying things that agrees with you, you want to repeat that in your argument because the judge is already there, so it's a short trip to agree with you. So that's a good tactical move by his part. He's using the judge's terminology to make his case now because, I mean, not that he's lying, I agree with him. But the judge phrased it into words that he knew and understood, and he's using the same term. Good on him.
Do this on the law, which is that it's unnecessary based on the fact that self-defense is going to be given, and the question is, was the use of force in the situation reasonable? That is contemplated by not giving 8-10. That's what the committee says.
My inclination is to give it, but if I find it's adequately covered in the other instructions, then I won't.
Okay.
All right, anything else?
Judge, I don't know if there's any jury instructions. Obviously, this case, anyone can pull up any video testimony of anyone testifying. I'm just wondering if the court feels it appropriate or allowable to play portions of testimony to the jury on closings.
You mean from media sources?
Yes.
Wants to play court TV.
Well, I'm not saying watch. I was saying we should talk about it now before anyone tries.
Well, that's a good point. I don't want to specify one. Court TV is certainly, and I might add, has done a magnificent job in this trial, in staying out of my way and just keeping things going. I think. So I'm not saying you shouldn't follow that. You could use any source that is carrying it, except not one where they're commenting on it one way or another. Of course, no one would do that. At least not if you knew it was good for them. So unless there's some objection.
Haven't they seen enough video and they get to watch their own video? Do we really need to bore the shit out of them by showing the same thing over and over again? And then we get to ad lib our eyes. Oh, do you see the gun? See, it's pointing. See, fired those 4 rounds. Let me pause at every fraction of a second. See, look how much time is in between those 4 shots. It's just more confusion. It doesn't matter. I mean, closings are always a freaking joke.
I don't have any problem with that.
I don't think it's appropriate.
We're not seeking to do it. I just wanted it out there before someone tried to do it.
I'm happy to agree that we're not going to do it.
Oh, okay, well, let's do
I
that.
want to be blindsided.
Let's
so.
do that. Okay, so there won't be anybody doing that. Now,
Oh, nobody doing it. Good.
but you bring up a good point. If the jury goes into deliberation and wants to look at some of this evidence, of course, one would read the law, I think, nowadays to say that any scrutiny by the jury should be in the presence of the court here in the courtroom. I very, very strongly disagree with that. I think that's antiquated. I think that that's based actually on a case I tried right here. Once again, I was there. State against Maurice Pucci Franklin, and I'm not going to go into my usual dissertation on that, but that led to, I think, the Anderson case about showing videos and things. The law actually developed around recorded statements of the accused as opposed to videos of the actual events. But I think the general rule now is supposed to be that we're supposed to do all this under judicial scrutiny, and they have to ask permission, and then we have to supervise. One of the things that I find most offensive is that we've got to scrutinize it to make sure they don't play it too many times, so they don't overemphasize some aspect of the evidence. I think that's what the cases say. And I think, how dare us, the founders of the Constitution, have juries because they don't trust the judges.
Man, good on this judge. Quoting the Constitution, that's like a sin. No wonder that little weasel DA don't like him. See, government power people hate the Constitution because it restricts them.
And the judges have spent the last 225 years returning the compliment by always suspecting that the juries are going to be up to no good. If this were a bench trial and like this, I watched it. How many times have I watched that video now? And you know what? I could sit and I could watch it maybe 50 more times. And in fact, the famous Boston Marathon bomber was resolved because an agent from the FBI watched the video over and over and over and over again, and finally realized what nobody else had caught, which was that Mr. Zainayev, who's now under death sentence, well, temporarily not. We don't know what the outcome will be in the Supreme Court, but that everybody else was looking one way and he was looking the other. And it took numerous times looking at the video to solve that crime. So for me to monitor how many times the jury looks at something, and if we're a bench trial, and I looked at it 100 times, and I finally decided I better not look at it anymore because I might prejudice myself, I get reversed, because that's an absurd thing to say. So I don't want to sit here and monitor how many times they look at something. I did that once when it was an attempted murder case of a police officer, and the jurors came down and they're told they can't even discuss it with one another, but they can't resist, and so they're saying, look at that, and then I send them upstairs and they're not looking at it again, and I think that's really frightening. So I think if they want to see the exhibits, we should give them the equipment to see it and let them do what they want with it. So that's what I think. Now let me hear from you.
Judge, I agree with you that is antiquated. I think this is the ideal case where giving them access or setting them up somehow with the exhibits would be great. I saw this as a issue.
Then just end it there. Then shut up. If you agree with it, let the other side agree and move on. You're going to keep rattling on for 20 more seconds.
I did ask people at the Department of Justice to look into it. Not a formal opinion. They indicated they believe it would be reversible error. I asked even if there was a stipulation and if the defendant agreed, and they thought it would still be reversible error under the current law, and also, and I'm not saying it would be ineffective, but they thought it would raise an ineffective assistance of counsel claim if there was a conviction. I do not want this case to be a test case on long-established law. I agree that the law is antiquated, and with the explosion of technology.
So he agrees, but he's basically telling him, don't do it because it'll be reversed, and we don't want to do it.
In the last couple decades, it needs to be changed, and perhaps we can do so legislatively, but as it stands now, the state feels that we should follow the procedures as antiquated they may be.
Defense?
I don't want them having a free-for-all up in the deliberation room.
Okay. Well, I'm not going to cram it down on this case. One day, with a short trial.
And the reason why he said with a short trial, because if it's appealed or you have to redo it, it's not a big deal. This is a pretty lengthy trial, and if this thing gets overturned or stuffed and you have to redo the whole case, it's a lot of work and a lot of time for everybody. So when he said a short case, that's what he meant. You know, you get a trial that's going to be over in a day or two, and that way if you got to redo it, it's not the end of the world.
Yeah. This is crazy. It's just absurd. And I'm the one, I guess, who was the dinosaur on technology, but I certainly respect it more than our law does. We need to talk about the lesser included offense instructions, Mr. Rittenhouse. The effect of these right now.
Okay, so I guess when he was talking about later, I got to talk to him alone. I thought he was going to pull him alone and talk to him. I was like, what the hell is he talking about? So here, what he does is he basically makes sure that the client has full knowledge of all his decisions and that his lawyers aren't railroading him and doing something that he didn't want to do. And so he's just going to go through a lot of questions about, you know, is there anything wrong with you? Are you feeling okay? Are you under the influence? Have you been drinking? I mean, he's going to cover all the bases. So later, Kyle can't come back and go, man, when I said that, I was A, B, C, D, whatever. And then they go, oh, man, then we can't really count your answer. So he wants to just make sure that the answer or position that he chooses is given with a clear conscience, clear head, and no, threats or intimidation, whatever.
Charges against you, which are stated in the amended information counts 1 through 6, the district attorney has to prove each of them beyond a reasonable doubt in order to obtain a conviction on that particular count. And there's something called lesser included offenses, and I'm sure your lawyers have discussed it with you, but I want to make sure that you understand it, and I'm required to do that. And if the district attorney is not able to establish your guilt on the charged offense beyond a reasonable doubt, then the jury is instructed that they must acquit you, find you not guilty. If a lesser included offense is presented to the jury, any of the ones we talked about, which are less serious crimes, carrying a lesser potential sentences, if I allow those, then the jury, if they are unable to agree that you're guilty of the charged offense, will have the opportunity to consider whether you're guilty of the less serious offense.
So this is a critical thing that I haven't really talked about yet, and I don't know how much you guys understand this. But so if I give you one charge of murder, the jury has to say you're guilty, you're innocent, or we hung. You're either guilty, not guilty, or we hung. We can't agree. So those are their only three options. DAs don't like that because they're afraid that if they didn't prove their case, instead of getting a hung jury, they may get acquittal, and then they're screwed. So by putting in these lower offenses, I think lesser included, or what, I forgot the legal term, but these crimes that kind of happen, like bank robbery. When I go in to rob a bank, I'm committing bank robbery. But if I bring a gun in, I'm committing assault with a deadly weapon. If I bring a bomb in, I'm also bringing an explosive into a building. When I enter a building to commit a crime, I'm committing burglary. Well, they're not going to charge you. They used to charge you with burglary, every one of them. They would charge every one. And then over time, they said, look, you got to charge the higher. You can't charge them with all. And then there was a problem. If they charged them with all, sometimes the verdict would reach on one and they wouldn't reach on the other. And there's no way to find guilty on the one they found guilty without finding guilty on the one they didn't find guilty, and they were appealing and all kind of shit. So they really, over time have kind of cleared that up, I guess, or tried to. So that's why the judge, if you remember, when he was questioning these, he was so important about how if they find guilty, you can't put a lesser included offense in there if they can vote guilty on that and the primary. Because if they find guilty on that, then they should have found it on the primary. So they can't be the same, I think it's elements of the crime is what we called it. To get convicted of murder one, you have to plan, you have to lie in wait, it has to be intentional, and you take someone's life. So, and I'm just going off the top of my head, each state will probably have more or less. Let's say I got to complete those 4 elements. Well, I can't charge you with another crime that has those same elements, because if they convict you of that, then they must have convicted you of murder, and since they didn't convict you of murder, how did they get to that? It was obviously a bad decision, and it's easy to get overturned. So that's why he's kind of saying, because I think if he objects, I don't know if the judge, I think a judge can. If the defendant says, I don't want lesser included, I'll take my chances with all the high ones. Well, that way, the jury has to either convict on murder or not convict. That's it. But if he gives lesser included and there's a couple of in the middles, they may go, I won't go for murder, but I'll go for one of the lesser ones. And then they can reach a verdict. So I'm not sure if it's a great idea to have lesser. It's good to have lesser because if you're really close on the high murder, the top charge, and they don't have anything else, they may be swayed to go ahead and vote guilty on that because they know you're guilty of something, but they don't want to let you go, and they don't have any other options. So I might as well just vote guilty on the murder because I can't just let you go. Where if you have lesser included offenses, it gives them someplace else to go to say, okay, I'll agree with that, I'll give them that. So it's a double-edged sword. You can kind of get screwed or you can win on either side.
And could return that as a verdict, as an alternative to instead returning a verdict of not guilty. So you are, by having a lesser included offense included, you're raising the risk of conviction, although you're avoiding the possibility that the jury will end up compromising on the more serious crime, and you're also decreasing the risk that you'll end up with a second trial because the jury is unable to agree. Any question about any of this so far?
No, Your Honor.
Okay. If the jury finds that none of the crimes charged in the sequence, charged or submitted, has been proved beyond a reasonable doubt, then they must acquit you. They must find you not guilty, and they cannot convict you of more than one crime on each count. Okay?
Yes, Your Honor.
Your lawyers have objected to some of the lesser included offenses and not others. They have, on some of them, they have agreed that they're appropriate. You don't have to join in that agreement if you don't want to, and you have the legal right to overrule them. And we'd have to talk more about it if you decided to do that, but you would have that legal right and say, no, I want to go to trial on just the charge offenses, all or nothing. And
now he's saying he has legal right. If the lawyers didn't want this, they would have told him, look, we're going to do this, but when he asks you, you should say you don't want it. They could have done that. But if they didn't really want it, they would just say, we don't want any, and we talked to our client, and he doesn't want any. So the fact that they haven't said that, you can kind of conclude that he's going to say he's okay with it.
And make the decision to force the district attorney to prove each case beyond a reasonable doubt. That would be your decision? Have you had enough time to talk with your lawyers about this?
I have.
Have you had enough time to think about what you're doing?
Yes, I have.
You think what you're doing is the best thing under all the circumstances?
Yes.
Has anybody threatened you or pressured you or forced you in any way?
No.
Has anybody promised you anything in exchange for this?
No, they haven't.
Is your mind clear today?
Yes.
Are you feeling all right?
Yes.
Have you ever been treated for a mental or emotional disorder? Well, let me ask you this. The more important question is there any reason for me to be concerned that you
Probably getting freaking taking meds or something from shooting two people. Kid's probably already in therapy.
have some kind of disability, mental or emotional, that would prevent you from being fully aware of what your options are and making a rational decision? Any reason I should be concerned?
Okay, you see the difference between those two things? The first question was, have you ever been mental therapy, mental issues, or something to that effect, which would have caused him to give up medical privileged information. So the judge reworded it now to where basically, are you aware and fully in control of your mental faculties, and is there anything that could impede that? And then he doesn't get into he's depriving medical issues later. That's the rewording.
About that?
No, Your Honor.
Okay. Any other question anybody wants to ask on this?
Was, I believe, because he's in therapy. I don't think he has a mental illness or anything.
Okay.
As a result of this incident,
Okay.
he has PTSD.
Okay.
Oh, he has been diagnosed with PTSD. Wow. And therapy. That didn't come up. They got to pull in on how the poor guy that got shot, that ran up and grabbed his gun, the piece of shit. They got the one that said he wished he'd have dumped his mag in him and then got his friend to come in and lie. They got to put him up there about how tough his deal is and how his surgeries, and he got to all get the sympathy of the jury. But they didn't get to say that on Kyle, did they?
And but that doesn't affect his judgment or reasoning power at all?
No.
He's wagging his head. Okay. Anything else before I accept his decision?
I'm assuming, I didn't hear him say that was a waiver, but I'm assuming they just took that as it's okay. Normally it's a little bit clearer, yes or no, but I must have missed it or I was talking.
Decision on this?
No.
All right. So I'll accept the waiver and start the court.
Maybe he did it right there. Sorry. What did you just say? Something? No.
It doesn't affect his judgment or reasoning power at all?
No.
He's wagging his head. Okay. Anything else before I accept his decision on this?
Before I accept his decision, did he give a decision?
All right. So I'll accept the waiver and instruct accordingly along the lines that I've already indicated. Anything else today?
Judge, while you were doing the colloquy, I looked at my email. I got another screenshot of someone saying someone on the jury. I forwarded it along just for transparency reasons.
Okay. He just said he got something from the jury. So when you see all these guys checking their phones and stuff, there's legitimate reasons on why in the middle of a trial things change. Certain people can text and check. So, I mean, it used to irritate me when they wouldn't let me bring my phone in, but they let. Now, if I was the case agent and I was looking for a witness and I had feelers out there or I had other cops going out checking and follow up on leads, I could have my phone and then I could communicate. I would usually leave the courtroom when I got it, but because it was in the course, I guess, of the trial. So when he's checking his phone and getting these texts, it's when the course of the trial. Now, obviously, guys get personal shit and you don't know whether it's in the course or not, but that's why they kind of allow that. And the judge, he's getting texts probably from legal advisors, maybe his friends, maybe his wife about what he wants for dinner. I don't know. I don't really care.
To the defense end of the court.
What did he say? The jury did what?
I forwarded it along.
Along the lines that I've already indicated. Anything else today?
Judge, while you were doing the colloquy, I looked at my email. I got another screenshot of someone saying someone on the jury. I forwarded it along.
I got a screenshot. They know something on one of the jurors? An email? What?
Just for transparency reasons. To the defense end of the court. Only one now.
Disappointed.
Must have been funny.
I didn't get it yet.
Oh, they must have been laughing about something else.
Oh, yeah, here it is. All right.
Come on, share it with us. Oh, that's not a good face. Oh, that's not a good reaction.
All right, thank you.
Maybe he was checking another text. The DA, the way the DA described it, it was nothing. And he was just sending for transparency and there was no problem. If the judge was reacting to what the DA sent him, that's a whole different reaction than what the DA just testified to. DA was like, let me send you something. It's nothing. I'm just sending it to you for transparency reasons. No big deal. If the judge was looking at what the DA sent, I think the judge thinks it might be a big deal. Is that it? What are we doing? Oh, we're at lunch maybe. All right. I guess we'll be back after lunch.